So after the admin, without further ado, it's time for tonight's main event. Slightly different theme to our previous science-focused talks. Tonight we're going to go branch out and look at a bigger picture. One of the things we've noticed in the space and astronomy field is a lot of very clever people are also idealists, and they focus on the technical and scientific side of space exploration. Space is a human endeavour done for human reasons and funded by people. So the social sciences are important, and any issues that occur on Earth are going to be replicated in the heavens. To help us all develop our understanding of that tonight, I'm really pleased to have a true expert in Dr. Thomas Cheney. Dr. Cheney is a lecturer in space governance within the multidisciplinary AstrobiologyOU group within the Open University. He's active in research in space law, policy and governance, and focuses on planetary protection and environmental aspects, as well as space resources and property rights. He was previously a co-lead on the Space Generation Advisory Council's Space Law and Policy Project, and has represented them at the United Nations Committee on the Peaceful Uses of Outer Space, so has been involved in the global conversation on space activities. Thomas is also an executive director of the Centre for Spacefaring Civilization and has got a PhD in space law from Northumbria University. So obviously an expert, and I'm looking forward to a really interesting and informative talk. And I'll hand over to now Thomas. Thank you, Thomas.
Excellent, thank you. I'm going to try and get it to share my screen, so that should hopefully work. Okay, so this is a sort of slide deck that I've developed over some time, so I won't necessarily go through all the slides. But it should give you a decent overview of what exactly space law and sort of the broader field of space governance is. So I've been with the Open University just over a year now. And as my title includes, I focus on lecture on space governance, and I sort of sit between the School of Earth, Environment and Ecosystem Sciences and the law school, because as you will come to find out, space is a very interdisciplinary field, and so there's lots of interactions between that. Skip over my personal background because I think that we covered that in our introduction. So I'd like to start with, well, what is international law? Space law ultimately is international law, and so this is a body of law that deals with relationships between states. And the sort of basic question is, well, where does it come from? What is the building blocks of international law? Fortunately, we actually have a specific laying out of the sources of international law in Article 38 of the Statute of the International Court of Justice, which is sort of the big international legal court that was set up at the same time as the United Nations was established. And so we've got a few different sources of law. So treaties are these are the main things. These are formal binding agreements between states. They're written documents. The states have legal obligations to adhere to them. The caveat to that is that only those states that are parties to these treaties are under the legal obligation to follow them. And so, you can have a treaty between 2 states, or you can have a treaty between 100 states. But if you're not party to the treaty, you're not expected to adhere to this treaty. Then we have customary international law, which, if you're familiar with English law, you may have heard of a similar sort of concept in English law. And this is specified as evidence of general practice accepted as law. Well, what does that mean? That's a very good question, and it is a bit complicated and convoluted, sometimes intentionally so. But essentially, it means things that states do in their general day-to-day behaviors with one another, that they do because they feel they're under a legal obligation to do so. And so not all general practices are necessarily customary international law. Because if a state is doing something simply because it thinks it's a good idea to do it, but doesn't feel under any legal obligation to do it, then that is not a customary international law, and vice versa. Then we have general principles of law. Again, a nice vague phrase. Essentially, these are sort of very high, ethically minded core principles of international law. There's a lot of disagreement as to what constitutes a general principle of international law, but they generally tend to be things like the prohibition on torture or the prohibition on genocide. And the idea behind these is that there is no excuse for committing these crimes, whereas some of the other things that you can do, some of the other rules of international law can be breached lawfully under certain circumstances. General principles of law are considered to be so high-minded that there is no excuse for violating these laws. Then we get case law. Again, if you're familiar with the English or the common law legal systems, case law features quite highly for us. But in international law, it's only a subsidiary source. So it's influential, it's not determinate. There is no obligation for international courts to follow previous decisions, and part of that rests on the nature of treaty law. So just because you have a case between, say, Chile and Argentina, doesn't mean that the relevant legal principles to that case necessarily apply to a case between, say, Britain and France, because we're parties to different treaties. So it simply wouldn't work for international law. And then the final sort of source of international law is the teachings of the most highly qualified publicists. Again, this is an influential source of law, but it's not determinate. The court can choose to disagree with these people. Who qualifies is a good open question. We very mainly talk, very highly regarded academics and senior legal people. So like an attorney general of a country and that sort of thing. Generally, they're not people like me. Although maybe in a few decades I will get to that status. So a bit more on custom, as I said, what is it? It's sort of a vague and kind of thing. There's loads of literature in the international law field as to, well, what exactly is customary international law. But I think the important things to consider are, the key points, the key ingredients are, what do states actually do? And that's state practice. But also, what do states think is the law? And then we generally throw in a final ingredient of time, but that's more of a kind of an identification process, because it's like, well, if states have done something for 50 years, then it's probably that they feel under some sort of obligation to do that. And so there's a lot of gray area when it comes to customary international law, which is why some people don't like it, but I find the concept fascinating, and really like to delve into it. But I won't bore you with too much with it today. Then we get into soft law, which is sort of what I spend most of my days looking at these days. These are non-binding norms. The definition soft law, the term soft law is something of a misnomer, because these are not legally binding agreements, and they come in multiple different forms. So a big one in the space field are UN General Assembly resolutions. These are, authoritative statements of the United Nations General Assembly. They're the closest thing we have to, say, a global parliament. So people take notice of what the UN says, but there is no legal obligation to adhere to them. It's just sort of like they're good ideas. You should follow them. So one of the big ones in space, for example, is the Space Debris Mitigation Guidelines, and this outlines how to, avoid cluttering up outer space with space debris inaccessibly. But there's no legal obligation to follow them. The benefits of them is that they're flexible, because they're relatively easy to produce. Because they're not legally binding, states are more willing to draft them and go along with them. But the downside of that is obviously you can't legally enforce them. You can't take anybody to court for violating the Space Debris Mitigation Guidelines. They're also worthwhile knowing is they can develop into binding norms through the development of customary international law. Again, that's something of an opaque process, and we can go into detail into what exactly that means. But it is part of a process that can happen. If enough states accept it over enough time, it can become binding. Also, soft law is important because it can be incorporated into national legislation. So while the state may not be subject to the provisions of the soft law as legally binding, they can make private corporations and citizens adhere to the law, to these soft laws through their national legislation. So space debris mitigation guidelines are a good example of this. Several states require private corporations to have space debris mitigation plans because they've made those provisions in national legislation. Their national space agencies don't have the same sort of legal obligations, because there is no binding international law, but they've managed to make binding national law. Now getting a bit more specific onto what our subject is today, what is space law? So hopefully all that will give you a reasonable introduction so you don't get totally lost when I go through all of this. But space law is unusually treaty dominated. I think partially because it's a relatively new field. It's only about 50 years old, which, at least in terms of international law, is a new field. And there hasn't been a huge amount or range of activities. With a few exceptions, most space activities has basically been orbiting satellites in low Earth orbit. So we have 5 main treaties that we focus on. All of these came out of the UN Committee on the Peaceful Uses of Outer Space, which currently meets in Vienna. Well, it hasn't met because of COVID, but it currently meets in Vienna, although it used to meet in New York. And so the big one, this is the one that everybody sort of starts with and focuses on, is the Outer Space Treaty. This is the most widely accepted treaty. It has, the last time I checked, I think it was 109 state parties. All of the spacefaring states are party to the Outer Space Treaty, including North Korea. And then we've got the Rescue Agreement, the Liability Convention, the Registration Convention, and these build on core principles of the Outer Space Treaty. And I'll go into a bit more detail on these in a moment. Then we have the Moon Agreement, and this is a controversial treaty. This is where it gets a little bit interesting, and we can debate as to whether it applies or not, because only about 17 countries have signed up to the Moon Agreement, and the big players, the Russians and the Americans, haven't signed up to the Moon Agreement, and they emphatically reject it. But it is a valid piece of international law. It received enough state parties to become a piece of international law, and therefore it applies to those states that are parties to the Moon Agreement, and so you can't completely ignore it. It's also worth noting that outer space, the law of outer space is firmly implanted within broader international law. So the human rights regime, for example, applies in outer space. Just because you're in space doesn't mean that you're free from the human rights legislation. We also have national legislation. So in the UK, we have several pieces of it that provide the obligations on British citizens or people living within UK jurisdiction. And then, as I've discussed, there are numerous soft law instruments that sort of flesh out the body of governance that, while perhaps not legally binding, people do recognize that it's important to adhere to these if we're to have some sort of order in outer space activity. So a bit more detail on the Outer Space Treaty itself. It was enacted in 1967, so it's getting on a bit. But it's recognized as the constitution of outer space. It's very widely regarded and highly accepted. There's lots of states have signed up to it. Many of its provisions are considered to have become customary international law now. So if you recall, even if you're not a party to the Outer Space Treaty, you are now expected to adhere to some of these principles. Some of the key ones, for example, are freedom of access and use of outer space. That says that all states are entitled to make use of outer space and should have access to it, regardless of the level of their technological development. We also have Article 2 of the Outer Space Treaty, which says that it contains the non-appropriation principle, which says that no state can take ownership over territory in outer space. And Article 1 and Article 2, working together, sort of make space a part of the global commons, which means that it's available for everybody, but no one can take a specific ownership over, say, celestial bodies or areas in space. There are a few more articles, but focusing on the more relevant ones, we get to Article 6, and this says that states are responsible for private or non-governmental actors in space. Now, this is really important and is becoming increasingly important as we move into commercialized realm. Whatever Elon Musk might want to claim, he can't do whatever he wants in space. The United States government is responsible for his activities. And therefore, they make him get a license from them for anything he wants to do, so that the U.S. government can make sure that he's not going to do anything that's going to get them in trouble. Most states have similar legislation. If you're a British citizen, the UK law says you need a license. Even if you're conducting your activity from outside of the UK territory, you still need a license from the UK government in order to conduct that activity. You probably also need a license from the state from wherever you're doing it, but that's a different matter. It's also important to remember that space, as declared by the Outer Space Treaty, is the province of all mankind. There again, showing its age. And for the space activities are supposed to be conducted for the benefit and in the interest of all countries. So again, this sort of means that you can't do whatever you want in outer space. Several space lawyers and even space ethicists have made the argument that we do need to consider this when we're talking about how we're going to use space. One example that got made by James Schwartz, who's a space ethicist, was, for example, like, you probably can't justify building a swimming pool on the moon because that's an extravagance. It doesn't really serve any benefit to anybody. But obviously, you could use the water on the moon for drinking or creating breathable air. All uses are not equal, and that does need to be considered in the context of the treaty when thinking about how we're proposing to use outer space. I'll keep that. That's a bit of detail. A bit more. Yeah, covered that already. Now we get to Article 9, which is my new favorite article. This is the one I sort of deal with in terms of the AstrobiologyOU project. Because Article 9 says that states shall avoid harmful contamination of other celestial bodies. It also says that states should avoid harmfully contaminating the Earth when they bring back extraterrestrial material. Now, as is something of a theme with space law, helpfully these terms are not really defined in the treaty regime, so we have to sort of figure out what they mean. And harmful contamination is quite a hard bar. It's not enough to contaminate a celestial body. You have to harmfully contaminate it, which of course begs the question, harmful to who or what? And in terrestrial environmental law, we generally tend to be concerned with harm to living organisms, to an ecosystem. But as there aren't really any living organisms that we know of in outer space, it sort of gets hard to make that a standard which people need to abide by. But I'll get into that in a bit when I talk more specifically about planetary protection. But it's certainly something to think about, especially from an ethical standpoint. What sort of ethical considerations do we have? Do we have to consider a precautionary principle? Do we act as if there might be life on Mars before considering doing things, or do we decide, well, Mars looks dead, so it probably is, so we can do whatever we want? You also need to avoid potentially harmful interference with the activities of other states. Again, what constitutes harmful interference isn't hugely defined. To date, it's generally been considered radio interference, but again, that's because most activities that have been conducted so far are, communication satellites in Earth orbit, so that's what's been relevant. If two lunar landing missions are trying to use the same bit of the moon, this may become more relevant. We should also consider that Article 11 of the Outer Space Treaty says that states should provide results of their exploration to the scientific community. Once again, most of these activities have so far been conducted by states. So NASA is perfectly happy to share their data with everybody. But if we start to see private exploration being conducted or commercial mining operations being undertaken, will countries continue to be so enthusiastic about sharing this data when it becomes proprietary information? We've also got a few other treaties, as I mentioned, the Rescue Agreement. This one expands upon one of the provisions of the Outer Space Treaty that provides for the rescue of astronauts in distress. It's a relic of the Cold War, actually, because both the US and the Soviet Union were worried that if somebody landed in the wrong country, that astronauts would be held as hostages. And it's not as absurd as it sounds. When spy planes were shot down, that's exactly what happened, and so there was genuine concern on both sides that would happen. But it does say that if an astronaut's in distress, you're supposed to provide assistance, and you're supposed to return them to their country of origin as soon as possible. However, again, as is becoming a running theme, it doesn't really define what it means by astronaut. And so one of the questions that we're currently having is, does a space tourist constitute an astronaut under the treaty? My personal opinion is it's meant to be a humanitarian treaty about rendering assistance for people in distress, and I don't really see a valid reason to exclude tourists from that assistance. But lawyers like to argue sometimes rather niche points to the ends of the earth. So that's probably what we're doing. Then we get to the Liability Convention, and this one is probably, in terms of like day-to-day operations of space law, probably one of the more important ones, because it deals with liability for damage, and it's basically who's responsible for making a payout. And there's different standards for whether if your satellite crashes onto Earth, then you're fully liable for the damages caused to the people on Earth. But if two satellites collide in orbit, then it's a fault-based system. But the big problem with this one becomes, how do we define who's at fault? And again, there's lots of discussion amongst the literature behind that. I don't really have an answer for you. I could do an entire presentation on this, although I don't, because liability is boring to me. So I can recommend somebody who can give you a much better presentation on the liability rules. But this is usually the main focus of national space laws, because it's the most relevant to the actual business of the space industry. Because obviously these are hugely expensive assets, and so any damage that gets caused to them is of significant economic concern. And as we all know, that's what rules the day. So then we get to the Registration Convention, and this sort of makes the Liability Convention work, because if you're going to be assigning blame and liability to people, you kind of need to know who owns what. And so I sort of liken the Registration Convention to requiring the license plates on cars. And it's quite a functional treaty in that sort of sense. Like, states have to have a registry. You need to be able to say this object belongs to this person, and you need to keep it up to date and stuff like that. So it's a bit boring as a treaty, but it's massively important. Then we get to the Moon Agreement, which, as I said before, is sort of a failed treaty, but it does introduce some interesting concepts. So in Article 4, we get this concept of intergenerational equity, the idea that we need to be concerned with the interests not just of the current generation but future generations, and so that has potentially has relevance for using space resources. Article 6 reaffirms the right to collect scientific samples from celestial bodies. We've got Article 7. This says that you need to prevent the disruption of the environment of celestial bodies. It goes a lot further than Article 9 of the Outer Space Treaty. It also says that it might be worth considering scientific reserves, i.e. cordoning off areas of certain celestial bodies and say only science can happen here. Commercial interests stay out. And then we get Article 11, and this introduces the concept of current heritage of mankind and stipulates that there needs to be an international regime for space resource utilization when it becomes feasible to do so. So obviously we've started to argue a lot more about Article 11 of the Moon Agreement in recent years, but as the key players in the space sector aren't parties to the Moon Agreement, it tends to get pushed away and so we say it's not relevant. Although interestingly enough, Australia, who's just signed the Artemis Accords, are one of the few parties to the Moon Agreement. So that could be interesting if we do ever actually have a legal subcommittee of the Committee of the Peaceful Use of Outer Space again to see what shenanigans happen there. Then is it. National legislation is the thing. States are required to have, essentially required to have national legislation in order to fulfill their obligations of Article 6 of the Outer Space Treaty. So in the United Kingdom, the two acts are the Outer Space Act of 1986 and the Space Industry Act of 2018. And there's a lot of provisions in them that I won't go into any great detail, but the basic gist of them, if you want to conduct a space activity anywhere in the world and you're a British national or subject to British jurisdiction, then you need to speak to the UK Space Agency and get yourself a license. And I'll speak a bit on planetary protection, sort of try to highlight a bit earlier. This is what I mainly do within AstrobiologyOU on a day-to-day basis. And so the planetary protection guidelines, the guidelines themselves are what we call, what I said it was, they're a soft law instrument, so they're non-binding. They're generated by an international non-governmental organization called COSPAR, which stands for the Committee on Space Research. Is one of those bodies that was founded right at the dawn of the space age. It's a very scientific, very respected body. And they produce these guidelines that go into quite a lot of detail on they even specify how much bacteria or spores you're allowed to have on a spacecraft in order for it to not be considered potentially contamination for relevant celestial bodies. It forms the basis for the specific planetary protection policies used by the space agencies like NASA, ESA, and the Japanese Space Agency. It's connected to Article 9 in the Outer Space Treaty in that there's a recognition that the two sort of cover the same thing, but it isn't state practice because it's not produced by a state, and it's also therefore not subsequent practice, so it's not a development of the Outer Space Treaty, so it doesn't sort of generate this kind of idea of customary international law, so I say it's soft law. And the national policies generally only apply to space agencies. Although, interestingly, in the new NASA planetary protection policy does say that the NASA planetary protection policy is the US implementing its obligations under Article 9 of the Outer Space Treaty, which should mean that those planetary protection policies will therefore apply to private corporations as part of the US licensing process. So that's potentially a really interesting and great development. But it's one of those, we're going to have to wait and see how that plays out in practice. And that could be a few decades before anybody does anything in which that would become relevant. But it's definitely one to watch. Then I sort of touched on this before. What exactly does harmful contamination mean? And so planetary protection principles themselves have only really been applied to biological and chemical contamination. So we're not necessarily talking about space junk here, although there are plenty of people who are starting to make the argument that maybe we should consider space junk as harmful contamination. But it's sort of trying to get into that nitty-gritty of there's two words in the Outer Space Treaty, and how much detail can we actually wring out of a relatively short provision? And can we build an international environmental law regime for outer space just based on this relatively limited provision? Well, I'm trying, giving it a go. You know, unfortunately, you know, the way that international environmental law is constructed doesn't really help, because it's about harm to the health of living organisms. And unfortunately, as we don't really have evidence of living organisms in outer space, at least not ones, with the exception of the ones that we've introduced, you know, exporting terrestrial environmental law to outer space is quite a challenge. Not impossible, but a challenge. I am exploring the possibility of whether we could use the harmful interference provisions, and sort of say, you know, could you, by contaminating certain areas of Mars, for example, are you interfering with areas of scientific interest? But that kind of relies on being able to use harmful interference for prospective future activities and not just currently ongoing activities. We also need to think about, you know, the sort of balance between science and sort of industry, or the development or colonization of outer space. Amongst a lot of the advocates for colonization of space, planetary protection is seen as a blocker of development. So people like Robert Zubrin of the Mars Society sort of wants to do away with the planetary protection principles. But we also need to consider that it's not necessarily a science versus industry question. Industry can fund science. Industry can be a friend to science. Industry uses science, and we see this in other fields. You know, for example, one of the primary source of funding for archaeology in the UK is actually the construction industry, because before you build anything in this country, you need to do an archaeological survey. You see the same sort of relationship with geology and the oil industry. Obviously, that's not without ethical issues, but we can also consider that this doesn't have to be a dichotomy of you can only do science or you can only do industry stuff. But I also think it's important to consider, why are we even interested in space? Why do we want to go to space? You know, surely the protection of the scientific value of outer space is fundamental to us, because, you know, we're not just going into outer space to see how much more stuff we can build, but we want to find out some of the fundamental questions about, you know, life in the universe. Often in law and governance, it usually comes down to trying to balance interests, and that's basically the rule of the day, that we need to balance the interests. For me, I lean towards science largely because there isn't any rush. We don't need to be building cities on Mars within my lifetime. We have the time to let the scientists do the science and find out all the interesting things, and then you can go and build your you know, monstrosities on the moon. That's not a popular view, I get, especially amongst the entrepreneurial people. But these things are becoming, you know, increasingly important, because space is becoming increasingly commercial. You know, we see it, if you pay attention to the space news, you see it every day, whether it's Elon Musk or Jeff Bezos or, you know, any number of other people. You know, there is a growing trend of people who want to go and do business in space. They want to open the frontier, and we need to recognize that their rationales are different. You know, Elon Musk cares about building cities on Mars. He doesn't really seem to care about whether there was past life on Mars. And understanding that should be factored into how we think about these things, because there's a certain amount of trust that's sort of built into the existing system, that, you know, nobody involved wants to do the wrong thing. Well, we might start to see bad actors, or people who define what constitutes a good actor in a very different way. You know, if the last 4 years on both sides of the Atlantic have taught us anything, it's that intent matters, particularly when the governance structures are relatively loosely constructed. You know, yes, we do have Article 6 of the Outer Space Treaty. States are supposed to take an interest in what their people are doing. But again, you know, we see in other regimes in international law that flags of convenience could become a thing. That's something we need to guard against and keep an eye out for. You know, soft law might be a solution, but, you know, again, it relies on trust. It relies on people doing the right thing because it's the right thing to do, or because they feel under a social obligation to do it. It's not like I can drag you in front of a court for violating a soft law provision. And so, you know, we need to talk to one another. We need to build a community. We need to share our ideas and what the future we want looks like, and make sure that we're all moving together, rather than fighting and arguing one another. Because if it comes down to competition, then usually it's the people with the biggest wallets who win, and that's very rarely the scientists. It's also worth considering, you know, what sort of ethical framework we want to operate under. You know, you can take this to degrees of absurdity. You know, what are the rights of microbes? Do rocks have rights? And there are plenty of you know, philosophers and ethicists who've explored these questions thoughtfully and in some detail. But ultimately, for me, that sort of rests on this question of, is space simply ours to do with as we please? You know, is it the new world but without the indigenous populations. So we don't need to worry about ethics in space because, well, there's no natives, so it's not like we're going to commit genocide. I don't agree with that principle. I'm on completely opposite the spectrum of that, but that is a view that you hear, that it's the Wild West but without the Indians, and so we don't have to worry about the ethics of it. Do we need to think about, well, if we're going to use water on the moon, then it's a precious resource, and we need to make sure that every use of water on the moon is done for a worthwhile purpose that benefits all of humanity. I've seen recently an article talking about having an RC race on the moon, and it's one of those questions of like, is that an appropriate use of the moon to have a toy car race? And I think these are the sort of questions that are asked too often in the space sector. We get caught up in the, oh, isn't that cool, rather than the, should we be doing this question, or is this the best use of our resources? I think we also need to think about unknown unknowns. There's a huge amount we don't know about outer space. Some of the time the proposals that you hear for using outer space, we talk about, well, we know that the solar system is basically devoid of life, or the moon has no life on it, or there's nothing interesting in any of the asteroids, so it doesn't matter. But do we know that? How certain are you that there's nothing of interest on this asteroid, so we can obliterate it into a billion pieces in order to extract the platinum from it? And I think, again, it goes back to the sort of what sort of world, what sort of future do we want to build? And I think this ties into the conduct of how, terrestrial research and our relationships with industry and the military. If you go on, this is something we touched on in the astrobiology group. If we're going to, say, developing countries to do analog field research, does it matter how we conduct that research? Does it matter how we interact with the local communities in those places? Similarly, a lot of space companies are fully embedded into the military-industrial complex. Does that matter? You're building a piece of equipment that could be used on an intercontinental ballistic missile. Do you put that out of your mind and decide, well, yeah, but the thing I'm building it for is to go into outer space. So what the military might be putting it to use for, it doesn't really matter. We often talk about a globalized space industry, and it is increasingly becoming so, but there's still a lot of siloed issues with, certain people from certain nationalities aren't allowed to be involved in certain aspects of space resource because they're considered research, because they're considered security risks. So how do we feel about these things? I'm not necessarily saying there's a definitive answer. I just think that it's good to ask these questions and interrogate ourselves. And so to sort of finish off, really, with a sort of a fun little question that I like to ask with, because I'm sure, like many of you, I've watched far too much Star Trek in my life, and that's probably why I'm here. So do we need a prime directive? We're looking for life. What happens if we find it? Or when we find it? Does it matter what we find? If, Professor Elson Francis of AstrobiologyOU finds, amoebas on Europa, do we say, oh, we don't care, it's only single-celled organisms? Or, do you need to be Mr. Spock in order for us to care whether you exist? Does the simple presence of life on the world make it a no-go zone? If we find some moss on Mars, do we decide that we're not going to touch Mars at all because, well, we've got to allow it and run the course of natural evolution? How do we measure intelligence? One of the things we're learning with animal research is that we're really, really bad at determining whether a non-human life form is intelligent. And like we're constantly surprised that pigs turn out to be far more intelligent than anyone thought. And what is the ethics of presuming that, well, if it's non-intelligent life, you can do whatever you want with it, particularly given that we might be wrong about how non-intelligent it is. And then I think, this is sort of a bigger picture question that I kind of just find fun of, if we do find extraterrestrial intelligence, how do we fit it into how do we consider of the legal universe? There's a scene in one of the Star Trek movies in which one of the characters says, and what about human rights? And the alien character says, yeah, there you go, human rights. Does E.T., does Alf, does Mr. Spock have human rights? What do we mean by there? Is human rights really just about valuing human life, or is it about valuing life and sentience in and of itself, and so would it extend to the extraterrestrials when they turn up? So there's probably loads of questions and not a whole lot of answers, but that's why this field really sort of appeals to me. And so I'm more than happy to answer any questions that you might have, or at least try to answer any questions you might have. So thank you.
Thank you very much, Thomas. Absolutely brilliant talk. I really enjoyed it, and I think, like all good talks, it probably leaves me more questions than I got answered there as an introduction. I think most of us on this talk, just like you, have watched far too much Star Trek, and that's exactly why we're here. So at this point, and before we go on to the questions session, I'd just like to close down for the people who are watching the recording and say thank you very much for watching on our YouTube channel. I hope you enjoyed the talk. There are other recordings available on there for the club, and we've got a wide-ranging schedule of future speakers planned, and just subscribe for notifications. And I look forward to having you as part of the space community.